Counsel of the King on the application of H7 and H15 and the Secretary of State.
Yes, good morning, Mr. Armstrong.
May it please the Court, I appear with my junior Miss Emma Dakin, and for the Secretary of State, Lisa Giovanetti, King's Counsel, and Richard Evans. Can I do a little housekeeping? I think this is all in order, but you should have a core bundle, a supplementary bundle which contains skeleton arguments, and an authorities bundle. Those are the only three bundles I think you need. I have just, I'm afraid, handed up an additional piece of Hansard, which is not going to detain you very long, but I will take you to in due course. Has that too.
If you want me to look at it, you better send it electronically.
It has been sent electronically to Linda Davidson, who
I am very concerned in this case, which is a case about statutory construction, that the authorities bundle does not contain a proper copy of the legislation, the entirety of the legislation,
right.
Nor does it contain proper copies of the historical legislation, which is extremely important to see what the legislation was pre-2013, to see how it was amended, to see precisely the entirety of it. What we've got is little bits, so I'm left to use legislation.gov to get it. And I really do want proper copies, electronic copies of the legislation as it was at each amendment stage, so that we can make a proper job of understanding what the legislator intended. It's perfectly obvious that that's what this case is about.
Well, I can only apologise. That's our fault. That's certainly my fault, and we will arrange to get those to you.
Thank you.
The only explanation I can give for that is that we haven't found any of that either in dispute or particularly useful to the way we've approached it. But my Lord may well be right, and I imagine is. So, but I'm sorry, we will get that, and if we need to do that, we'll do
Please
that.
get your solicitors or juniors to do it. Thank you.
Well, I'll causing inquiries to be made behind me, and I will see how fast that can be done.
We don't need an inquiry, we just need the documents.
Certainly, but the inquiry was about how long it's going to take and whether I can get it by lunchtime. It may take a little longer than that, depending.
Well, I mean, as far as I'm concerned, I just want it when we leave here.
Yes.
Because
yes, of course.
I need to have a wet towel around my head to see what the legislation was meant to say.
Yes. Well, yeah. Certainly we will do that. I mean, my Lord, you will. Can I say what I'm going to do? And I'll touch on that as I introduce it. The idea between my learned friend and I is that I speak until probably lunchtime, and then my learned friend takes over at 2 o'clock, and then I'll do a reply. But I am going to do this. I hope, and you will stop me if I do too much of this, I am going to spend chunks of the morning telling you things that or reminding you of things that you know much better than I do, including about statutory construction. And I hope I'm not going to do too much about that. But I'm going to take the grounds in order, but I'm going to run grounds 1 to 3 largely together under one foundational submission, which is I am going to say that the intention behind this legislation, plus the plain words of this legislation, create ample power to award costs, at least on set aside of the application, but also under section 2D3 more generally. And once you have broad language plus clear statutory intent, the orthodox approach to statutory construction is that can only be cut down by implication. And in the area where that cuts across either rights or fundamental tenets of the common law, that can only be cut down by necessary implication. And all of the points, and there are a number that my learned friend takes and which the court below took, are insufficient to do that, to cut across that wording. And that is why I say it has, for such a long period of time, since 2013 when these amendments were made, the courts have proceeded on the basis that this was, and on at least one occasion held, that they could do this in the area of reviews rather than appeals. And that is, as you will see, I've made the point, and Lady Justice Lane picked it up in the grant of permission, we have 4 experienced High Court judges, all of whom either held or assumed that power existed on set aside. And they're all SIAC experienced judges, so they are.
So are you saying that in the area of appeals, there has not been a common practice of awarding costs, but in the area of reviews, there has been a common practice of awarding costs?
I can't establish any number. There are no costs orders. This doesn't appear to have come up very often. And my lord, the only reason, I don't know the reason for that, other than not that many of these cases succeed. But as I will show you by reference to cases like Ignaua, which I'm mispronouncing, it has at least been decided or assumed by all that the costs power exists once set aside takes place. And I do say that reviews are very different to appeals because of the way they were brought about and because they were taken from judicial review in the administrative court into the commission. And
they're very different from appeals because of the way they came about and
because the obvious comparator is judicial reviews in the administrative court. These were judicial reviews in the administrative court until Section 2D and the rest of these 2013 amendments were made. So, and you see that particularly starkly with the cases that I now represent, H7 and H15, where they were running their cases. They had refusals. They advanced their cases in the administrative court. They won twice, to the extent that the decisions were withdrawn. A new decision comes in, the certification then takes place, and they are then taken into SIAC. These men had costs orders in their favour in the administrative court. They succeed. The economics of those cases work for various reasons. They are then taken into SIAC, process over which they have no control, that transfer over which they have no control, and they lose that. And I do say that that's a significant thing. One of the other things that I am going to say is that this court, on a number of occasions, in the context of M. and Croydon orders and those sorts of things, has on a number of occasions recognised that a fundamental part of what keeps the civil justice system working from a funding point of view is the availability of inter partes costs. And the system has adjusted around that. The market has adjusted around that. Solicitors' firms have organised themselves around that. And things like conditional fees have come to bear because of things like that, all of which depends upon inter partes costs. And to remove all of that from a cohort that previously had them, and one of the things that this additional piece of Hansard said...
I mean, that's a forensic argument, right? Unfortunately, you have to get over the statutory construction argument first. But you have to get to a stage where there is one available construction which you win on.
Yes.
I mean, at the moment, you're the appellant.
Yes. Yeah. I understand, but I also have the forensic advantage of this sort of sotto voce, is that I'm only arguing for a construction that 4 experienced SIAC judges, High Court judges, all assumed was correct. That should make the hurdle that I have to overcome that my lord identifies slightly lower, I hope. I mean, that's Mr. Justice Inslee missed the argument. Well, but it's also the reason I'm emphasising it is, I say that I get there on plain words anyway, but if one is removing, with the effect of this is to remove from this cohort a benefit from which they previously benefited, then that needed to be done with clear wording, and that's fundamental statutory construction. So it's not just a forensic point.
Mr. Armstrong, if this sort of case had arisen before 2013, would the costs regime in JR in the administrative court have been one where, in principle, the Secretary of State could have got her costs?
Yes, I accept that.
Yeah, so what you're advocating is that in 2013, without Parliament or anyone else apparently explaining why, the decision was taken to allow your cohort to continue to have the benefit of the admin court costs regime, but to deprive the Secretary of State of that.
Yes, without any discussion and without any authorisation of that or explanation as to why.
Yeah,
Yes,
yeah.
I accept that.
Yeah.
Except if I rely on the wide language used in section 2D3 as well as section 2D4, and if I get it as a principle, because M. Croydon is a principle as opposed to because it's any order or relief, then that problem doesn't arise. But I say my fundamental point about section 2D4 is, again, my foundational point is broad language plus clear intent just to transfer them in means that my learned friend now has to say it's a necessary implication that they intended to remove this. And I say you can't do that for lots of reasons. To the extent that she says, well, I can because look, that only on set aside means that something different is happening, then one has to say, is that reservation, that qualification that only on set aside, is that the reason why it's all different? And I say no, in line with what Mr. Justice Jay held in the Commission, because the most likely, when you're looking at what that means, the most likely, the best interpretation of what that means is just to deprive the Secretary of State of costs, not to make a complete change to the position of applicants, because I remind you, and I know the court knows this, and I'm sorry, that when a client comes into a solicitor's firm and wants to run these cases and gets a certification decision of this kind, then the client doesn't know, obviously, what is in the closed material, so has to launch the proceedings to engage the system and to engage the special advocates, as I know you in particular, my lord, know. That means it can't be unreasonable for an applicant to commence proceedings because he simply doesn't know what's enclosed. Absent something quite exceptional, I can't think of what it would be. It's going to be reasonable for them to commence proceedings, in which case, why would you ever get a costs order against you?
Well, Mr. Armstrong, I understand all of that. I'm approaching it like my lord at the level of what is the correct statutory construction.
Yes, of course.
What's the answer in principle? Now, suppose, I'm not talking about the facts of your case, but suppose someone in your client's position behaves completely unreasonably in the conduct of the SIAC proceedings and wastes the Secretary of State's costs, for example, because there's a last-minute application for an adjournment or something like that, and she's incurred a brief fee or whatever it is. Right? So they want to apply for costs. And it's such an extreme situation that even if you had not the usual costs regime, but something like the employment tribunal regime where costs are only awarded if there's been unreasonable conduct, you would otherwise satisfy it. But your submission is it, that the correct construction of the statute is that there's never any power to award costs in favour of the Secretary of State?
My primary submission is if this should all be done under section 2D3, and the language of 2D3 is elastic enough to allow this,
right.
And 2D4 wouldn't prohibit an unreasonable conduct power being brought in via the rules. But what you can't do is construe it to say, when you have language that says any such order or any such relief, you take away this foundational part of the civil justice system.
So you genuinely, I mean, just looking at 2D3, it says, in determining whether the decision should be set aside, the Commission must apply the principles which would be applied in judicial review proceedings. And you say that brings in the entirety of the judicial review. What would the costs orders that could be made in judicial review proceedings?
Yes, because...
But how does it do that when the qualification, I mean, call me a chancery lawyer if you like, when the qualification is in determining whether the decision should be set aside, not in making an order generally?
Well, one has to construe those phrases. And I do recognise that it's more difficult in relation to section 2D3, and that's the usual term of principles, and it sounds like that. But you have to construe this by reference to, it's an elastic term, principles, and one of the principles of judicial review that one sees described as a principle in cases like M. and Croydon and others is that if you win, you will get your costs. It is if you largely win, you will get your costs. And that is at least capable of being construed, it's an elastic term, in the way that I say, and it avoids all of these problems. And the reverse construction is much greater, which is that you have this period. I mean,
the problem, sorry, Mr. Armstrong. I mean, I get that your construction is the more sensible one.
Yeah.
I mean, I completely get that. I mean, to have this regime without a costs provision is absurd, right? But when you look at the,
Thank you.
well, I think so. When you look at the legislation, what actually happened was that Section 5, which allows the Lord Chancellor to overlay procedural provisions by regulation, was there first.
Yeah.
And obviously the legislator, up until 2013, intended there to be a costs regime, if there were to be one, imposed by the Chancellor by regulations. Right. That didn't happen. In 2013, the legislators, must be taken to have known that had not happened.
Yes.
And they then put in this legislation, this additional bit about reviews, which we can see in 6A sort of is done in a very cumbersome way by reference to appeals, goodness knows what. And they put in what is going to happen on reviews in similar language for several different types of review. And, but I mean, in 3 and 4, to me anyway, they're not talking about what might or might not have been done under 5. They're talking about in determining whether the decision should be set aside, first point, 3, and if the Commission decides the decision should be set aside. It's together. The two subsections are together. And so they're not talking about what happens if the decision is not set aside. So your construction there sort of runs into a bit of a hurdle. Now, I can completely understand why you say if the decision is set aside, not our case, there is power under 4 to order costs.
Yep.
Because it says so, almost in terms.
Yes.
But it doesn't go further than that. So it seems to me anyway, at first sight, that there is a ridiculous lacuna here that the legislature has connived in, because it could have seen it coming, knowing in 2013 that there had been no regulations, and putting in place this provision, which seems to be not competent to do the job that could otherwise have been done by regulations. So with that, if I'm right about all that, where does it leave us?
Well, I'm grateful for the indications about the lacuna and the absurdity of this.
That's
and it
what
has all sorts of consequences.
Yeah.
And I understand why that construction is the one my Lord alights upon, but I push back at it because, firstly, the orthodox approach to statutory construction is, I say, when you have, let's just start with whether 2D4 allows for it at the end on set aside, and that is resisted by both the High Court. That wasn't its construction. That's resisted by my learned friend.
Sorry, just say that again. You went quick. You push back on.
So the section 2, let's just focus on section 2D4 and whether I even get costs if it's set aside. And at the moment, both the High Court and my learned friend are against me on that. They say not even then. They say that is only concerned with substantive matters, final orders, not, and that doesn't include costs. And I say that can't be right because it's broad language and look at what they were trying to do. But I do also say, this is where
the most important submission is it's broad language.
Very broad language. Any order,
but I mean,
any
it's
relief.
not just broad language, it's clear language.
I agree.
It says, give any such relief as may be made or given in judicial review proceedings.
Yes.
Now, you say, do you, that includes costs because of section
2D4.
24?
2D4, yeah. I say that language gets me costs.
Or you would say, even if relief for some reason doesn't embrace that, certainly any such order does.
Yes, absolutely. It couldn't. How else could they have done it? What other language could they have used? And then I say that the court below has construed that as meaning substantive. That means any substantive relief, or possibly any final relief. And that's just words that aren't in the section and gives rise to problems about what does substantive mean. We then have to think about when is an order a substantive order and when is it an ancillary order and when is it somewhere in the middle. And that's just a gloss on that's just a gloss on broad language that's impermissible. That's my orthodox approach to
But even if you're right, it doesn't get you home in this case.
Well, because of the withdrawal phenomenon.
Yes.
Yeah, no, I know that. But the reason why I'm pushing back, and essentially my argument about pushing back on and trying to bring it in via the principles provision, and also trying to get over the Rule 11A withdrawal situation, is because when you have elastic language, not even the clear language of 2D4, elastic language of principles, and you have the clear statutory intention, and I say I do, then you've got sufficient leeway as a court in construing this to give the outcome that I am seeking.
Well, you need to unpack that submission. I've tried to write it down. You go quite quickly.
Sorry.
But you need to unpack it. When you have elastic language and clear statutory intention, you have such leeway. The problem with it is you don't, in this case, have elastic language or clear statutory intention. The clear statutory intention is in section 5, but procedural matters will be dealt with by the Lord Chancellor's regulations.
Yep.
And that's the case from whenever this legislation was first enacted, 98 or whenever it was. And you then have what is really very clear language in 4 and 3 and 4. You have, it's not very elastic in determining whether the decision should be set aside. That's a very focused provision. And I know, you're probably a public lawyer and I'm probably not by training, but I've done a bit of it since then. And you can't call that elastic language in determining whether the decision should be set aside. That's very clear. And then 4 tells you that it's still talking about that because it says if the Commission decides it should be set aside. So it looks as if the legislation is against the background of Section 5, making a very specific broad provision, which doesn't go far enough, is obviously stupid, but is not very elastic. That's my problem.
Well, but the word but if you're with me on section 2D4 giving me costs absent the withdrawal situation, then that's good enough for me.
Seems to me it includes it at the moment, but I mean, I'll hear Mr.
Subject to withdrawal.
Benetti, yes.
The reason why I'm just trying to get principles more elastically or flexibly interpreted.
Yeah.
In section
Where do you
2.
get these principles that you can completely ride
Well, it's just
horses through
it's
these
just
words?
well because it's if you are going to where I say the statutory purpose gets me, together with sort of central tenets of common law, is when one looks at such Hansard material as we do have and the background, and you see how Mr. Justice Ousley was dealing with it in Ignaura, and you look at other assumptions that are made along the way, they were transferring these cases in, and they were transferring them in immediately. They were going to occupy the space completely. And we'll look at Ignaura in a moment. And the assumption was being made, that is all that would now happen. They would all go into SIAC. And Ignaura stayed the proceedings in the judicial review and ran them into that. Now, if you're going to do that immediately, and you are going to take away something which is a fundamental, it's more than an ancillary matter. It is a foundational issue. I am saying this is more, cost is more than a mere ancillary procedural matter. It's foundational because it goes to things like access to justice.
Well, you're saying you don't take away foundational rights by accident, and that's what they've done.
True. So that's an ex parte Sims type submission. But I am going to show you.
So what type submission?
The ex parte Sims legality point, you can't take away fundamental rights.
I mean, you are going to
Right.
have to go for some of these cases.
I-
you keep on.
Well,
chucking
shall I do that, my lord?
Yeah.
no. But I am making the point, and I do want to come back to this, which is, it really is fundamental if you are going to strip these things away, because inter partes costs are now a fundamental part of the way the civil justice system operates, and this court has recognised it on a number of occasions in the context of when it should make costs orders. But you, and we'll look at Ignua in a moment. They had a privately funded client there. If they were forcibly transferring him into SIAC and saying, you now won't get your costs, so you're going to have to pay your own legal team, then that is a really fundamental thing to do for
You won't be at risk of costs either. I mean, it's not unusual in our legal system for there to be a cost-free regime or a limited cost regime. See the employment tribunal, see the upper tribunal. There is express provision in those sorts of contexts. So I'm afraid, at least speaking only for myself, you are going to have to persuade me that you're right, that a case like Unison, which is about fees for bringing a case, can somehow be read across to costs, which I don't think are necessarily treated in principle in the same way as restricting fundamental access. Sometimes it's said, actually, having a cost-free regime encourages access to courts because it means that you can go to court knowing you won't be at risk of costs.
But FGF, for example, has a conditional fee agreement. He's got a conditional fee agreement because that was the understanding that costs were available. You've got things like C7, you've got things like Ignua saying that costs are available to you. So in principle, your only route into access to justice is that you've got Dighton Pearce Glynn and me signing a conditional fee agreement.
Mr. Armstrong, isn't your argument to my lord not that the argument to to my lord is not that you can't read Unison across because it restricts fundamental access to justice. It's because in this case what was done was to withdraw a right to costs, which was very important part of the regime, and you cannot do that by a side wind for the reasons that you're going to explain in more detail. And I think it comes down to your legality argument, because I'm not quite sure how you put it, but to persuade me of this, you've got two of us, perhaps it's coming from slightly different angles. You're going to have to show me why that can't be done in a situation where, of course you're right, if in the administrative court you had a right to costs, the legislation bringing this whole regime into SIAC, the review regime into SIAC, changed all that.
Yes.
You're going to have to show me why you can't change the cost regime for good legal reasons by a side wind, because if the legislature made, as I think it did, a mistake, or at least created a lacuna.
Yes. Well, yes, my lord, and I will do that. Can I just make another point before I move on then in relation to this? But the conditional fee point is agreement, as my lord will know, the way conditional fees work, is you define the consequence. The liability on a conditional fee arises when you win. Win is then defined in the conditional fee, and they're relatively standard wording for these things. So if you get a positive order of some kind, you get a win, then the client's liability for costs follows. Now, in a case like this, if you got a positive order in SIAC, then the liability would kick in. But if you've got a costs order, it will generally be paid by the costs of the other side. But if you can't get that, therefore, these conditional fees don't work. They depend upon the existence of inter partes costs, or they are depriving the client of a substantial amount of money, which is then a deprivation, and that's relevant for Article 1.
When you're pushing into an open door on that, it's absolutely obvious that you can't have conditional fee agreements if there's no cost regime.
But I want to just finish with this point before we go on. My learned friend says it's perfectly fine and not incompatible with things like Article 14 to say we'll leave it to the Lord Chancellor. But if we leave it to the Lord Chancellor, these applicants, FGF, H7 and H15, have no remedy. So they will not be able to remedy the fact that, I mean, I should deal with the fact of FGF briefly, is that he has now run subsequent SIAC application with other solicitors, has now failed, and is now withdrawing all of that and can't go to appeal. And I'm told on instructions that part of the reason for that is the uncertainty around costs. So he has lost the facility, predictably, because there are not people like DPG acting for him previously on a discounted conditional fee. That has a real impact for him, and he has no remedy.
I mean, if I may say so, of course, this case wouldn't be where it is today if there were not real-world consequences of the problem that we're debating. But actually, the real-world consequences, however serious they are, can't, unless you have a legal principle which allows you to overcome a statutory consequence, the real construction of a statute, you can't get over it that easily. So you do need to go to the legal principle that lets you change the natural meaning of words in a statute.
Yes, well, that, I mean, it sounds like, you're at least partly with me on the fact that 2D4 gives that.
I'm not with you.
If I've overcome that,
I'm
I won't spend so much time.
telling you what my impressions are.
Yeah,
At
the rest
10,
of the court's
11 o'clock in the morning, I may be in a different place at 2:30.
I understand. My lords, can I just take a step back and say, do I need to, well, just as statutory construction tools, I am going to say both domestically under Singh's and Unison type principles, I get there domestically. I'm also going to say Article 14, if I need it, more muscularly under Section 3 of the Human Rights Act, also gets me through, and I'll address you on that in due course and have a debate.
Well, you're going to have a bit of an uphill struggle with seeing the relevance of Article 14 to this case at all, but you're entitled to try and persuade us.
I will just make this point by way of introduction on it. If you are going to remove from a cohort of people who previously enjoyed an arrangement, and
I get that point,
then you're at least within the very low threshold of ambit of Article 1 First Protocol. And then back to the point, and your point about absurdity, my lord, which I will take and use if I may.
Of course you can.
Which is what's the justification for this? You've got a comparison. You've made it worse for them. There isn't any explanation for it. There are explanations that
the trouble is, of course you're right, but the trouble is the absurdity is patent, not obscured. It's patent. Everybody knows it, including the legislature. So the legislature knows in 2013 that these regulations have not been made. And for whatever reason, it may assume they're going to be made next week. I don't know. It doesn't matter. But it knows when it legislates they have not been made, and yet it chooses to introduce a very clear provision saying something which we'll loosely call, obviously we don't mean it about our legislature, absurd.
Yeah. But my lord, the way I push back slightly on that is I don't think they did think that. I think they thought they were transferring judicial reviews in, and absent some minor level procedural tweaking about which they could lead.
But you're going to show us your lovely Hansard, which I've now got electronically.
Well, I'll come. Can I just, before I go to that, just because I'm just watching the clock and making sure I cover things.
Yeah.
I'm assuming, I hope I'm not wrong about this, that I don't have to argue about standing, given my learned friend's very helpful position on standing. Yeah. I have already touched on the facts, but they're in my skeleton, so I won't deal with them. I just want to make sure you understand FGF conditional fee agreement. That's how he advanced his case. You understand the factual background. He then ends up in SIAC. He runs his case. It's withdrawn. The only point I would just remind you of, again, is that he got a costs order in his favour in SIAC. There isn't any challenge to that. The Croydon analysis produced a costs order on his favour. But it is just important that there is no challenge here, factually, to the fact that the justice of this case is that he gets a costs order but for the jurisdictional point. The reason why he has played no part in these proceedings is because the Home Office wouldn't commit to not seeking a costs order against him. And I just notice the stark nature of that particular point is that you can run a case, win it, get a costs order, but then the challenge to the costs order may lose. So you not only result in you not getting your costs but having costs order against you is a pretty stark injustice, one might think. And the point about H7 and H8, H7 and H15 is...
So the SSHD would not commit to not seeking costs against FGF in these proceedings,
True.
on this appeal.
And that's why FGF has dropped out. To
And
avoid
do
the
you
costs.
say that it is, do you say that if you lose this case, a costs order could be awarded against you?
Yes. I mean, probably not against FGF now because he's played no part in the proceedings since inception. But I mean, H7 and H15 have got a costs order against them, subject to their legal aid protection. But FGF didn't have the benefit of legal aid
So
protection.
they had a costs order against them in the judicial review proceedings.
True.
Nothing to do with the statute.
Yes, in the judicial review proceedings. This is an
But
operation.
that is the ordinary pre-2013 regime,
Yeah.
Which means that you are not only able in principle to get your costs, but you are susceptible to costs order against you.
That's true, but if you're standing where FGF is and going, I can't continue with my
No,
case.
I understand.
And I, you know,
Could be described as a double whammy.
indeed. Can I also just make this point? I was just going to pick up as I was going through with my Lord Justice Singh. Is the position here is that this cohort of individuals is worse off not just than the judicial review cohort, they're also worse off than the tribunal cohort, because the in most tribunal appeals, as my Lord has already alluded to, you get unreasonable conduct costs orders. And you don't even get that for them. So if you're in a position where, say, the proceedings are withdrawn unreasonably, and that happens in trouble. So say the decision is withdrawn unreasonably, it's done last minute. You know, you're right at the door of the court. My Lord probably has experience of this. You see this, or certainly we used to see this quite frequently. And there are a lot of the ARAC cases appear to get withdrawn. You don't even get your costs in those circumstances. So what is the justification for treating this cohort so much worse? And the only justification really that you can see is they didn't think about it. It's a lacuna. They didn't think about it.
But can we? It's maybe a lacuna. It doesn't mean we can fill holes in the legislation that are patent at the time the legislation was enacted.
Well, you can definitely construe Section 2D4 as giving me the power at the end.
I mean, you do understand the problem you have about 2D4, because the problem about 2D4 is it follows 2D3.
Well, but if I've got a...
It's all about the same thing.
No, I understand they're not about this. Well, I say that the 2D3 and bringing in the principles of judicial review could be construed as including principles where costs are recoverable. That is a sufficiently elastic, broad term to permit that. In relation to Section 2D4, I'm sorry if I'm being slow. I'm not sure I understand my Lord's concern. I say that...
But just let me explain it to you. If you've got the statute there.
Yeah.
It's 2D3 says, in determining whether the decision should be set aside, that's about determining whether the decision should be set aside, you have to apply principles applied in judicial review. And 2D4 follows that, saying, and if the Commission decides that the decision should be set aside, it can make any order it likes.
Yes.
So the whole 3 and 4 are talking about the decision to set aside and what happens once the set-aside decision is made.
Yes. Well,
But
I
to construe that as meaning in any case in which we are considering whether to set aside a decision is a wholesale change to the legislative intent as disclosed by the words. What I described as my chancery point.
Well, but at the moment, this is being construed against me on the basis that 2D4, even at that stage, even on set-aside, I don't.
Yeah, well, I'm not interested in what other people say. I'm putting the points to you that I think. I mean, I may be wrong and I may be right, but at the moment, that's my problem with this.
Well, but even if I've got my Lord, if you're at the point where 2D, and obviously the rest of the court agrees with you, that 2D4 gives me it at the end, my only hurdle then is the Rule 11A point. And I say that that can be put to one side because that non-contemporaneous bit of delegated legislation can't drive the construction of what is broad language and where Parliament intended these things to just be transferred in. When one looks at the Hansard here,
Yeah, well, we haven't looked.
and looked at, I know I'm going to get to it, this was just a transfer in. They weren't talking about these consequences because nobody expected this to be anything different to judicial review. That's what I'm saying.
Can we just see it? Because you keep on talking about it. Well, it can't be very long. I've got it on the screen.
Sorry, what?
The Hansard.
Yeah, so, can I just do it this way? Can I go in the, can I just go to the core bundle first of all, our skeleton argument? Because I'm going to use these to introduce it.
Mm-hmm.
And if you go to page 27 of the core bundle, now, my learned friend and I may disagree about what this means, but I don't think we disagree about what these things say. And this is paragraph 32 of my skeleton. It's just a convenient way of doing it at a bit of speed.
Yeah.
So what happened here is the background was Al-Rawahi and a case called AHK, which you'll see referred to again in a moment. That the problem that they wanted to fix was the absence of closed material procedures. So there was then a parliamentary choice, paragraph B, either introduce a CMP into the admin court or transfer these into SIAC, and they chose the latter course. I then at C just draw attention to the explanatory notes, and remarks made in Parliament. At that stage, the language in terms of explaining the effect of this, and this may go to your point about when determining the application, slightly different language was being used at that point, when considering the application, which is arguably broader. SIAC is to apply the same principles as would be applied in judicial review proceedings and may grant the same relief given in judicial review proceedings. That's pretty broad statement of intent that we intend these to replicate judicial reviews. That's why you get what Mr. Justice J said at paragraph D, and remember again, he was, I think, probably a SIAC judge at this point, certainly involved in this work at this point, and was well aware of this, and is saying the from cradle to grave formulation that he had. And can I also, just while we're there, just stay with Mr. Justice J for a moment, can we just go into the supplementary bundle and go to page 214? Because again, this is the formulation that I adopt and supports the evidence and supports what he understood was going on and what others understood was going on. That formulation, can I just invite you to
Paragraph. Which paragraph on page 214?
47.
47.
So that's again his understanding, and I adopt that. If you then
But
go
I mean,
back,
all he's really saying is there's no reason of purpose and or policy why SIAC should not possess all the powers of the High Court in these circumstances. I mean, we all agree about that. You know.
well, I think my learned friend may not.
Well,
but
okay, but you know, maybe my lord doesn't either, because he may say it's perfectly rational to have a regime where there is no power to order costs, and I would accept that. But you cannot go directly without passing go or collecting £200, as Mr. Justice J and you seem to want to, from thinking there's no good policy reason to exclude the costs to saying that the legislation doesn't do what it says on the face.
to the extent that you're against me on whether, I mean, again, I think we are agreed that at least on set aside 2D4 gives that power. I am saying that it ought to be construed as giving it at other stages as well.
How
Although
can it? That's my
because
problem.
because what is happening here is you're not just introducing two unconnected parallel processes. You are taking something away, particularly H7 and H15.
Yeah, well, where's the authority? Show me a case where you can't take something away by clear statutory language.
Well, I mean that's the legality point. which I'll come to in a moment. But and Article 14 stronger again in relation to that.
Just before you forgive, if my board will forgive me, since we're in 2013 and the changes are made, have I understood the position correctly that between 1997 and 2013, what SIAC had dealt with was appeals?
Yes,
yeah.
I think that's right.
Yeah, and now, as has been authoritatively held by this court in C7,
Yes.
in the context of appeals, it has no power to award costs because there are no rules in place. So, in principle, the power to create a costs regime does exist,
Yep.
but that's a matter for the Lord Chancellor.
Yep.
So, in the absence of rules made by the Lord Chancellor, the position was, in 2013, that what Parliament was doing was putting these review cases into a regime where there was, as yet, no costs regime in existence at all.
Yeah, and that's, yes.
And it may be that my views at this stage, and obviously we've got to hear everyone, we've only started hearing this appeal, so I have no concluded views, but to my mind at least, it's not necessarily absurd that Parliament should take the view in 2013 that in principle we want there to be a costs regime for these review cases just as we do for appeal cases. And see section 6, capital A, which says that that appeal includes review. And this is the point the Divisional Court made in its reasoning. So I don't see necessarily anything absurd about Parliament taking the view in 2013 that we are content for there to be a costs regime to govern review cases, but that's going to have to be done just as it is in appeals, through the Lord Chancellor making the rules.
The problem with that, my Lord, respectfully, is that they come from judicial reviews, and this is happening to extant judicial reviews.
I understand.
So, and this would be so difficult, and cases like Ignore would have to go the other way if you're going to suddenly say, we've got these cases, in H7 and H15 type cases, you've won twice, the Secretary of State keeps withdrawing the decision to try and improve the quality of the reasons or whatever they're doing, but now it's potentially uneconomic for you to continue. So you will now lose simply because we have changed the economics.
We get the practical realities. I just make 2 points. My Lord says it's not absurd to have no cost regime. I completely agree with that. What I was suggesting to you might be absurd is to introduce this hedged around condition for there being any costs in 2D4. And the second thing is, when you say the problem with it, with what my Lord put to you, is that reviews come from a JR situation in the first place, and therefore you're taking something away, that all comes back, as this whole case comes back to your fundamental point, that you can't do that.
Yes.
So we need to look at the reason why you can't do that.
Okay. I will, can I just, I was looking at the Hansard, and I just want to add the point that I handed out. And it's making good the point about this. This is going to happen, when they do this, it's going to happen immediately. And it's supposed to be a seamless transition. The point that I've just handed up is from a November 2012 bit of Hansard from Lord Taylor of Holbeach, who was at the time Parliamentary Undersecretary of the Home Office, was introducing an amendment, in fact a transitional, all this was doing was introducing provision, and it's important to see this because when we look at Ignova, what was happening here is the amendment was just to make sure that there was a power to make transitional arrangements so that you could seamlessly move them across. And they didn't quite do that in here. The power was introduced, this happened, but the rules in fact did something slightly different, but that doesn't matter at the moment. And if you just look at the second column, so moved by Lord Taylor of Holbeach, you have that schedule being introduced, and that schedule was introduced. Then as he begins to speak, can you see where it says, currently we have a rather unsatisfactory arrangement whereby the only course of action open is to seek judicial review. Problem is that our High Court doesn't have the capacity for closed proceedings. The JR claim is therefore stymied. That's that paragraph. Then he refers to AHK. Again, this is all foundational. This is what all they are trying to do is get a closed material procedure in place. They're not messing around with cost arrangements, which then go to things like access. All they're doing is, I say, is transferring in and finding the most convenient way of adding a closed material procedure. Then, the amendments before the House are intended to ensure a tidy transition from the old arrangements towards the new arrangement in which SIAC will consider the application to review decisions such as these. So it is moving them in. They will occupy the space. This will be the only way of doing it. And over the page, if you would, third line down, talking about the transition and allowing for transitional arrangements.
So you rely on tidy transition.
And then the next page, the government are keen to allow for a seamless and fair, which I emphasise, transitions from old arrangements to new. It would not do to have a two-tier system in operation, in which judicial review proceedings already before the courts will continue to be heard in the imperfect setting of the High Court. And then they talk about some of what the transitional arrangements might be. The claimant be given an opportunity to apply to have their case heard afresh in SIAC, where a decision can be made that takes into account all of the relevant evidence. And what they in fact did was just extend time for people to bring new challenges that would then go into SIAC. But this sets up Ignova, which I'm going to go to next. So then it says there will be a number of cases that will be running in parallel, and then it says this at the middle of the second sentence. It would be preferable for the Secretary of State to be able to certify material as sensitive on or after commencement, thereby transferring the venue. So again, relying on that, that's what was being done. I should add that the amendments will allow for the rulemaking power from the day that the bill receives royal assent. This is consistent with the rulemaking power already set out in the bill. Again, at the bottom, this will ensure that we are fair when offering individuals a suitable avenue of redress in respect of decisions that have been made against them, and will eliminate the possibility of inconsistency as to how we go about that. Be fair, eliminate inconsistency. So I rely on that as saying, this is what, you're going to have to do it this way now, applicants, but this is an appropriate way of doing things, and it's not unfair to you. If you were removing the cost regime from them, it was extremely unfair, particularly to anybody who was privately funded, CFA funded, or who needed inter partes costs to have their solicitors. And then that sets up, that is the context for Ignova. If I could just show you that, because it's quite important, in the authorities bundle at 2110, please.
210.
Yes, so this is a decision of Mr. Justice Ousley and Mr. Justice Irwin. Again, I make the forensic point to experienced SIAC judges. They know what is going on here. And you see paragraph 3, referring back to Al-Rawahi and AHK, as I've already pointed out. That's a paragraph 3. Paragraph 4, what has happened is the cases have got stayed and they're trying to work out what to do with them. Can they continue as judicial review, or they go in as SIAC? There's an account of the procedural history. Can you then jump forward to page 219, please, where the conclusions start, at paragraph 28. And if you see the first question at the end of paragraph 28, first question is whether these cases should follow the section 6 route or the SIAC route. 29. First, the legislative steer is of some weight. A specific provision was made enabling this type of case to go to SIAC rather than stay in the admin court. The subject matter is very much within SIAC's remit. Indeed, the legislative steer envisages that existing proceedings would be terminated by some test or mechanism as let lawfully to be devised. They weren't, that was the enabling power that I just referred to, and that wasn't brought in, they did it differently. But that sets up what everybody's understanding is happening. Then he starts at paragraph 31 talking about the advantages of the SIAC route. And then if you go paragraph 34, it's difficult to see what disadvantages there are to SIAC dealing with claims. That wouldn't be true if it was without costs. They will continue to be presided over by a High Court judge. Sections 2, C and D make it clear that it's judicial review principles. He notes absence of interim relief in SIAC. I say it doesn't actually have to be that way, but I don't need it to be, because you could get it in via principles, but I don't need it for these purposes. But then paragraph 38. Indeed, there is an advantage for a losing claimant, particularly privately funded as is HN. There are privately funded applicants in SIAC. Section 2C provides only for relief to be given if the direction is set aside. This enables a successful claimant to claim costs from the Secretary of State, but it doesn't work the other way around. He's got no concerns about it being the other way around, and the point that we are discussing. And I say that's the better interpretation of Section 2D4, because, as I say, it's always going to be reasonable for you to start proceedings, because it's the only way you can engage special advocates and have a facility for having the reasons probed. And then and then he finishes at paragraph 39 with concluding that the cases should be stayed so that they can proceed in SIAC. The balance of advantage and fairness and the effective administrative justice lies in that course of action. Now, that is him deciding, as part of his reasoning for proceeding in the way that he did, and so it was part of the ratio in that decision. The court below took a different view. It doesn't matter at this level, of course, because it doesn't bind you anyway. But what it does tell you is some evidential assistance to me as well, because it is saying what the expectation is with these cases. They're just being transferred in. It's a convenient way of adding a CMP. We're not going to do anything other fundamental. We're certainly not going to trespass on removing costs and making it at least much harder for a significant number of individuals to access the process. Now, where that then takes, so that's where I say the purposes, my lord. I'm now going to move and show you the cases that I rely on about when can you cut down a broad power. And a broad power is particularly in section 2D4. Can I show you, stay with the abundance of authorities and go to page 843. This is from Bennion on the use of broad terms. And if you see 3 or 4 paragraphs down where the title is Courts Not to Give Own Definition.
What's the broad term here?
The broad term here is any order or any relief. So I'm supporting the point I think my lord has already taken. And I'm also saying in relation to the word principles. If you're going to say that, as the High Court did here, the High Court said that's not what it means substantive relief. It doesn't say substantive, it doesn't use final. It can't do this, so I'm respectfully agreeing with my lord.
I mean, obviously I understand that submission.
But I also say it in relation to the word principles. Why can't principles include costs principles? Then at 844, narrowing of term by implication, yours towards the bottom above the example, the width of a broad term when read in context may be cut down by implication. And now I'm going to show you how that then works in a couple of different ways. Can I do that first? I need to emphasise one point which comes from a case called the Morgan-Grenfell case, which is at page 85 of the authorities bundle. Because the court's likely to be, you do see slightly different language here. The court likely to be familiar with the principle, the Sims principle, which is the legality principle, which you can't cut across fundamental rights. But it's not confined to just cutting across fundamental rights. It's also about not cutting across something called the basic tenet of the common law, which in this case was privilege. So it's sometimes expressed differently. And if you look at page 85, which is the decision of the House of Lords in Morgan-Grenfell and Special Commission of Income Tax, the appeal was allowed, just in the head note, allowing the appeal and quashing the notice. This was whether or not privileged material could be sought. That legal professional privilege was a fundamental human right that could be overridden only by express words or necessary implication. That Section 21 of the 1970 Act didn't exclude it expressly, and it was not a necessary implication in the structure of the 1970 Act as a whole. If you then look at paragraph from Lord Hobhouse at page 136, paragraph 43. The question is one of statutory construction, that's how he's approaching it. Paragraph 44, the next step in the legal analysis is not disputed and was expressly adopted by the Court of Appeal. The principle of statutory construction is succinctly stated in a quotation from the speech of Lord Hoffman, and then he quotes the well-known passage in Sims. But then he says this, context in which...
Sorry, which paragraph are you in?
That's in paragraph 44 now, on page 137.
Ah, sorry, must be in the Court of Appeal. 137.
Yeah, sorry, it's, because it's an appeal cases report, so it's got all of it in. So page 137, you've got paragraph 44, he says, he quotes ex parte Sims, you can't cut across fundamental rights without clear language. Then he says this, the context in which Lord Hoffman was speaking was human rights, but the principle of statutory construction is not new and has long been applied in relation to the question whether a statute is to be read as having overridden some basic tenet of the common law. And I say that in this context at least, a basic tenet of the common law includes that in civil proceedings costs will generally follow the event. And that is what was happening in these cases. So you would need to have, we say, clear language to remove that. I have an argument about whether right to cost is a fundamental right, but it's certainly, we say, a basic tenet of the common law, which when you want...
that you should be able to recover costs that you see on the side.
Yes, I mean, in civil proceedings, that's the rule. I mean, that is the long-standing common law provision in relation to civil proceedings. Costs will generally follow the event in civil proceedings, and these were, as judicial reviews, civil proceedings.
But actually, the submission you are advancing has the consequence that costs will not follow the event, only in one direction.
But that's done in clear language.
Yeah, no.
The rest of it is not. So that is a necessary implication, but the opposite is not.
But you're not able to show us anything in Hansard, anything in explanatory notes, any preparatory material which shows that this was thought about and that a deliberate decision was made to make it asymmetrical.
I'm afraid that's true.
Yeah, now that's why tentatively and provisionally only, I put to you an alternative way of viewing what's happened is that Parliament did not intend to create an asymmetrical cost regime, but was content to move these cases into a forum where it knew that there wasn't a cost regime, but there could be a cost regime, and then the Lord Chancellor would make all the rules which would tell us, for example, whether only one side can ever recover its costs, or both sides can in principle. It would tell us what the criteria should be for the award of costs, such as whether it's costs follow the event, as in CPR, or whether it's unreasonable conduct, for example.
But that is one of the constructions that is available, but it is not the best construction in my submission. The best construction is that all of that making it one way means reflects the fact that it's not unreasonable to start proceedings. We'll never have a costs order that way. That's the natural reading of those words and the most natural way of doing it. But particularly when you read it alongside the statutory construction and direction of travel, which is that they were just transferring in. The silence on this, I say, the Hansard, which is not helpful for anybody, including this court, but the silence on this, I say, helps me, because if they were going to do something as fundamental as mess with CFAs and inter-partes costs and all of the other things that come with this, and take away a right or a facility that you previously enjoyed, then you would have said something about it. The only way of construing the silence is to say that they just assumed that this was going to look like judicial review. And you have got these statutory clear language steers. They are saying, as I've shown you in the explanatory notes, when considering the application and when you've considered the application, we want this to look like a JR. You see that in the language, you see that in the Hansard such as it is. It is. I realise that there are lacunae in all of this, but that's why I say go my way. And I also say go my way because if we don't go my way, then these individuals who are affected immediately by these provisions can't wait for the Lord Chancellor to get round to doing something about it. And I would also just notice in parentheses that the Lord Chancellor appears not to have thought about this either because nothing has happened for 13 years. That wasn't, and the court and Ignua and anybody else thought that wasn't the position. Can I just make good also the point that I've talked about, which is how important this is? Can I just go briefly to unison, just to remind you, and I know you'll be familiar with it, but it's just the strength of this point is important to what I'm trying to do. Now, of course, and that's a page 313 of the authorities manual. And you remember that this is about tribunal fees, and I can probably just do some of this from the head note on page 814, the holding. The points that I'm just want to emphasise is the rule of law link here. This is about getting people into courts, not just for their own sake, but it's an important part of maintaining the rule of law. So if you look on 814 in the holding, allowing the appeal that since access to the courts was not only of value to the particular individuals involved, but played an important role in maintaining the rule of law by enabling the courts to carry out their function of interpreting, applying and enforcing the laws made by Parliament, the constitutional right of access to the courts was inherent in the rule of law, that had been recognised by the courts, etc., and all of that down there. And then just by letter C, if you're going to do it, if you're going to cut it back, you need authorisations required not only when the hindrance or impediment made access to the courts completely impossible, but also where there was a real risk the person would effectively be prevented from having access to justice, that the question whether court or tribunal fees effectively prevented access to justice had to be decided according to the likely impact. And I just want to mention that because it links it all into the rule of law. That must be all the stronger, the importance of the rule of law, of having proper scrutiny of what the Secretary of State is doing when you're in a closed material procedure. I mean, ensuring proper access to checking all of that is happening properly must be all the more important when you're excluded from part of it. But also, I am in a factually different scenario because it's not about fees, it's about the availability of inter partes costs. But that is also, for the reasons I've said, an impediment, and I don't need it to make things completely impossible. I only need there to be a real risk that persons would effectively be prevented from having access. And that is true with privately funded individuals and FGF, who was reliant on a conditional fee. As I say, I only need a real risk, and for that, you can see that in paragraph. Can I just show you the paragraphs that the head note's drawn from, which is firstly paragraph 68, which is at page 340. I know you'll be familiar with all of this, but it's worth remembering the strength of this point in unimpeded access. I'm just pointing out where the sideline is, and can I emphasise at paragraph 77 paragraph 78. At the bottom there, more recent authorities make it clear that any hindrance or impediment by the executive requires clear authorisation.
I mean, the problem is the clear authorisation. You know, what's happened here is they have put you into a regime where no rules have been made yet, but rules may be made, and legislated pretty clearly in 3 and 4, right? And so all these authorities that say you don't do things by a side wind don't apply if it's not a side wind.
But they,
I mean, they may have made a legislative error, but we can't correct a legislative error if what it means is clear.
but why can't I have an order for costs at least on set aside as the High
At least
Court, on set aside? If I succeed and I get the order set aside, I can get any order or any relief.
Well, there is no. I mean, it's been withdrawn, so there's
Well,
nothing.
but that's a separate argument. I'll come back onto the withdrawal situation in due course. But the
I'm
primary legislation.
suggesting to you, I'm suggesting something different from my lord.
I know.
I'm suggesting that it's perfectly clear that 4 is perfectly clear when the court is making a set-aside order,
Yep.
has made a set-aside order, can do what it likes. That's clear legislative provision. And it's a one-way provision, and it's
Yep.
illogical for a number of reasons, but that's what it says. But it doesn't go any further than that because of the very clear wording and the introducing both 3 and 4. And at the moment, all these authorities they say that if you don't do things by a side wind or secondary legislation and so on and so on. But
Well, I will take that because that's enough to get me at least part of the way home. That I can get it set aside. But I'm
my
saying,
lord says, well, it's perfectly obvious that it should be construed as by reference to Section 5 and Section 6A as meaning that the regime is only in Section 6 and this is only about substantive relief. Now, to my way of thinking at the moment, that involves reading in a word that is simply not there in 4. But that's what the divisional court said, and that's what Ms. Genovati says.
yes, I know, and I understand that, and I am respectfully disagreeing with my Lord Justice Singh about.
Yeah, but I mean that's where the parameters are drawn. But the third solution, which is that Section 4 gives a general cost power, I don't see, just because it's brought in, just because it was previously in judicial review and it's taking something away. I mean, it may be taking something away, but it's taking it away expressly.
I don't argue that 2D4 gives it in other circumstances,
No.
except on set aside. I can't do that.
You
I
don't
agree
do
with my
that.
Lord on that. But I do say that principles of judicial review under 2D3 might do that, because if you want to take something away, you don't use as broad a word as principles. That's my submission there.
Yeah.
And then once I've established, with my Lord, that they do intend to give a costs power on set aside, then my Lord's remaining concern, which I'll come back to, but I'll flag for the moment, is that it's then taken away by 11A. But the difficulty with that point is you're then trying to narrow the very clear language of 2D4, which is any order or any relief, by reference to non-contemporaneous delegated legislation, which my learned friend will say you have to assume that that was something that Parliament had in mind. Mr. Justice J says that's far too recondite a provision for them to have had in mind, and I'm with, respectfully, Mr. Justice J on that. And you see tenets of that, you see parts of that thinking in cases like Morn, the inquest case about standards of proof, which I can go to, where there is this issue about delegated legislation and being taken to understand it can be used as a construction tool to some extent, but there are limits to that because you can't do, Morn says, things of principle in things like schedules without drawing Parliament's attention to it. And that must apply also to things like delegate. That supports Mr. Justice Jay's approach, which is to say, in 2013, when you're introducing this, the idea that Parliament would have in mind the rules, the withdrawal scenario in relation to appeals that existed in 2007 but doesn't say anything about costs is too much of a stretch to use the existence of that as a construction tool for 2D4. And I say Mr. Justice Jay is right in that, and he's supported by some of what is said by the Supreme Court in Moore. So that's where I go on 11. Once my Lord, if I've persuaded you, or you've already concluded that 2D4 gives it to you at the end, I say that the terms of 11A can't take it away again. That it cannot put it in these terms. It cannot bear that weight. It can't remove that which would otherwise be there.
It's not removing anything, is it? I mean,
Well, what it says is you would otherwise have a costs order now. You would otherwise have the facility for a costs order now, but not if the Secretary of State suddenly withdraws the decision. That's why, because as soon as the Secretary of State withdraws, this is the argument, 11A means that it has to be treated as withdrawn. There's no other role for the Commission. There is therefore no set-aside, and the Secretary of State has managed to sort of neatly sidestep the potential liability. And the Secretary of State can do that at any time, in any circumstances, and on this construction, however unreasonably, and there'll never be any cost penalty.
I mean, if I may say so, it's a slightly weird argument, because 11A is not taking anything away at all. 11A is unrelated to 2D, 3 and 4. 2D, 3 and 4 is saying what happens in court, and 11A is saying what happens if you don't get to court.
Well, I respectfully agree with that. But the argument against it is that 11A has the consequence that 2D4 no longer has any operation, because
well, it doesn't have any operation because 2D4 and 2D3 are about determining whether the decision should be set aside and deciding that the decision should be set aside. And 11A is a procedural provision about what happens if an application is withdrawn. In order to get a cost order when an application is withdrawn, you need a cost regime that applies to the proceedings, which, as I understand it, you do say there is, but I still don't quite understand how you get that.
We mean the cost proceedings, or you're talking about detailed assessment proceedings?
No, a costs regime
Yep.
that applies to the application to SIAC. So an application is made to SIAC, and the very minute that the application is made, and a cost regime of the kind in judicial review applies immediately. So as soon as you make an application for judicial review, the court has power to order costs in relation to whatever happens thereafter and what has happened in the issue of the judicial review procedure. And as I understand it, you say that was a human right or something else before. Parliament can't have taken it away, and it applies irrespective of 2D, 3 and 4. There is a cost regime, and therefore, if they withdraw and you've incurred costs, they must pay. The court can, as a matter of discretion, as it could in JR, make a cost order. But that's what I'm balking at, because I place, I mean, I'll be absolutely honest about it, and I place great weight on the words of the statute. I don't see how you get round those. I don't actually see how the divisional court got round the words of the statute, but what they did was say obiter something that doesn't apply to you.
Well, my answer to that is there should be a cost regime that applies all the way through.
There should be.
And I rely on 2D3 as my best hope of getting to that. I've definitely got it on set aside at 2D4. That I think my Lord is with me on. But I'm now trying to read judicial shrugging, but but that can't be with, once you've done that, it can't have been the statutory intention to remove it via the operation of Rule 11A, because that places too much weight on a procedural provision about withdrawal that pre-existed these provisions.
And what I'm putting to you is that 11A doesn't withdraw anything. it doesn't remove anything. 11A is simply a procedural provision that applies where an appeal is withdrawn. Simply that. Now,
But
you need to
Okay.
explain to me how you get to the turn of phrase. You can't withdraw what 2D4 gives you by 11A, because I don't even understand that submission.
well, but I think that's my learned friend submission. That's what that is. That 2D4 is the only route to a costs power.
Mm-hmm.
I can only have a costs power if it's set aside. I never get to set aside
Yeah.
if it's been withdrawn.
Yeah.
And 11A, that's what 11A is, preventing or withdrawing or whatever language you want to use.
Well, I mean, but how do you?
I say it doesn't. I think I'm agreeing with you.
No, I don't think you are. I think you're saying that the withdrawal of an appeal is not, or should be regarded as a decision to set aside, which it's not.
Well, no, I'm not saying that the withdrawal is a set aside. I'm saying that once it is, you can take 11A as then saying it is treated as withdrawn, but there is then a further procedural step, and this is Mr. Justice Jay's analysis, that requires you a judicial step, and it is that further procedural step that is to set aside.
Right. Which further procedural step?
That is where they give effect to the withdrawal. And that's Mr. Justice Jay's analysis too.
Well, you better show me where he says that.
Hang on. I'm jumping ahead a lot here. I need to come back to do the HRA, but it's paragraph 48 onwards, which is in the supplementary appeal bundle of I think around 214. So paragraph 48, you see, having decided that there is a costs power, paragraph 48, he says, it follows that Ms. Giovanetti's principal argument must be but what of her alternative contention, that the power exists only if SIAC makes a decision. It does not exist if the decision is withdrawn. And then he goes through, in paragraph 50, we have to say that this argument lacks appeal. It would carry the day if having seen the way in which, and then he talks about the risk of abuse, because...
Well, this is all very colourful, but what's the substance of it?
Well, he is saying that to construe Rule 11A that way, as removing this, can't have been what was intended.
Where does he say that?
Because it's, well, that's what I think he's saying. Paragraph 50 is saying he's talking about the absurd consequences of this because it's a risk of abuse. One is you could just be halfway through a SIAC hearing. Secretary of State sees he's going to lose, or she's going to lose. I think even, yes, as of yesterday.
But that is confusing statutory construction with the merits. I quite understand the merits.
It's the canon of construction.
Where does he say why Miss Giovanetti was wrong when she said what was a very promising argument that 2D4 doesn't apply if the decision is withdrawn? And
Where he says we have to say that this argument lacks appeal.
I know it lacks appeal, but why is it wrong?
And he then goes through 52.
Yeah, 52 is quite important to your case, and 53 to some extent. But what he's saying at 52 is that even after there's been a withdrawal, it can't be a unilateral act on the part of the SSHD. SIAC still has to do something, which brings the proceedings to an end. But if I may respectfully say so, that's begging the question what SIAC has to do and whether that means it is setting aside a decision. And the simple point made against you is by then there's nothing to set aside.
Yeah.
What's wrong with that argument?
Because when you are construing what this does, are we construing Rule 11A as having this effect? The answer to that is no, because if you construe it that way, it has these absurd effects, and those absurd effects can't have been intended.
But what I'm putting to you, I think, is really, in substance, what my Lord has put to you, which is nothing to do with 11A. It's simply that if they withdraw their decision, there's nothing for SIAC to set aside, and therefore it isn't triggering the express provision on which you rely, which says if SIAC sets aside the decision.
The consequences of this are so grave that the statutory tools available to you, either because of domestic law or because of Article 14, are strong enough, I say, to say that that is in fact, that can be construed as being a set aside. You are giving effect to the withdrawal, but the way you are giving effect to it is setting it aside. Because the consequences of that are so grave, and because you would then be treating it so differently to judicial review, which is why he says at the end of paragraph 53, Mr. Armstrong is right to draw as complete a parallel as possible with judicial review proceedings. So if you're construing...
If we were in the administrative court and this had happened, analytically, what would one be saying? That it would be very straightforward there, wouldn't it? There would have to be a consent order, but not because of all these intricacies of analysis, but because there is a full costs regime in the administrative court. So even if a decision has been withdrawn, you're not governed by the language of 2D subsection 4, which says if the High Court sets aside, as my Lord has said, from the moment somebody issues the proceedings, there is a full costs regime in place. So you don't need to worry about all of these sorts of things.
I agree, of course.
But the trouble is, as my Lord has said to you, here we can't just get around the wording of the Act. The wording of the Act, the very provision you rely on, has a condition attached to it. And the simple argument made against you is you don't satisfy that condition.
But that depends upon how you construe that condition. And when is a set aside a set aside? Is that is at least open to a degree of construction, either as a fact of domestic construction or as a fact of Article 14. And because otherwise you are treating this cohort, that all, as I say, all of the legislative steers are to treat them identically, or as identically as they can be, say for adding on a closed material proceeding and whatever that has to be done, and the appointment of special advocates, etc. But it doesn't mean you do something as fundamental as this, which is as fundamental as it is particularly for the likes of FGF, H7 and H15, which is where the impact is very dramatic. And you say Parliament can't have intended that, and therefore set aside must be construed as including the situation where it is withdrawn, that the Commission then has to give effect to it. Can I just, that's essentially the Rule 11A submission. I'll see if I have to deal with anything else coming back to that. Can I just go back? I'm watching the clock, so I need to be slightly... And I want to leave a little time to deal with... can I just, for your... Can I just make sure that you've got these points before I move into Article 14? There was evidence before both SIAC and the Divisional Court from Mr. Carey, who sits behind me. Can I just deal quickly with that? That's in the supplementary bundle at page 83, but I just want to, so you understand and have at the forefront of your minds the impact of this in terms of inter partes costs.
Is this page 63?
Page 83 of the supplementary bundle.
80.
Same to Daniel Carey.
Yep.
And there's no challenge to any of this, and it sits with other things that you will know. Paragraph 4, talking about the decline in legal aid and legal aid rates. Quoting the Law Society President at the top of page 85. Fees have not been increased since 1996. Paragraph 8, The consequence of this is that securing inter partes cost recovery is crucial for sustaining this firm's work, and if they don't have it, they will have to do significantly less of the work as a result. And then at paragraph 10, he references some cases that talk about that, and I know that my lords will be familiar with some of those cases. I know my Lord Justice Singh may have sat on it. Yeah, in fact, you're quoted towards the end of paragraph 10. But can I just, that line of authorities that talks about the importance of inter partes cost has continued. Can I just show you Lord Justice Nuji at page 746, and yeah, sorry, 746 of the bundle.
Authorities bundle.
The authorities bundle, yeah.
That seems to be Lord Justice Baker.
Hang on. Oh yeah, sorry. Lord Justice Baker, Lord Justice Nuji, but it's Lord Justice Nuji I'm going to go to in a moment. And Lady Justice Yip. This is an appeal against a costs order which succeeds. It's a partial costs order and it succeeded. And if you go to paragraph 56, page 763.
This is all very familiar, Mr. Armstrong.
Yeah, I know.
And nobody has said the contrary in recent years.
Understand. But can I make this point? It's a limited point that I'm going for, which is page, bottom of paragraph 56 and paragraph 57 from Lord Justice Nuji. Inter partes rates are likely to be between 3 and 5 times the legal aid rates. So what happens is that firms are completely dependent upon this because legal aid is completely uneconomic. And then 57, the ability to recover costs of inter partes rates where the claim has succeeded has a practical importance in terms of the financial viability of any legal aid practice, same as Mr. Carey's point, and hence in terms of access to justice. This is the point that I am making about it being a fundamental part of the system that this court has recognised repeatedly over the years. So that is, why removing it is such a substantial thing to do. Well, as I was then going to go to all of the, I think we've dealt with this in questioning, dealing with, and I make the headline submission that all of the things that my learned friend says about you can leave it to the Lord Chancellor and the rules power, section 5, etc. You can read in language doesn't work.
I mean, you must tackle the argument that is made against you. That the argument is not you can leave it to the Lord Chancellor. The argument is that Parliament left it to the Lord Chancellor. That there is a clear provision allowing procedural rules to be made to govern the SIAC procedure, and Section 5 allows that. Now you have to tackle that. You may have lots of answers to it, but you can't just say you can leave it to the Lord Chancellor as if it's a possible solution. That's not what's said. What's said is you must construe the statute as envisaging, in the words of the parliamentarians, that if there were to be costs, they would be introduced by the Lord Chancellor. In other words, C7 argument.
For this reason, C7 is different because it's not dealing with the judicial review scenario and it doesn't have the sort of panoply.
But except Section 6A says the judicial review, the review is the same as an appeal.
But what is it doing? So firstly, if you have a provision which wasn't true in C7, it's in relation to appeals, that says any such order or any such relief, my learned friend says that means no order of costs at all, even on set-aside. No order of costs at all, because Section 5 and Section 6A mean leave it to the Lord Chancellor. That's the intention, Lord Chancellor will deal with it. You cannot read language as broad as that, any such order or any such relief, as in fact meaning you can have it if the Lord Chancellor later approves it at some point in rules. That is a gloss. You can't do that.
Mm-hmm.
You definitely can't do it if you do it by reference to what these provisions actually say. What Parliament, if it had thought about these things at all, there's no suggestion that it did, is talking about, if you look at section 5, the detail of section 5, Court of Appeal in the on page 30. It is talking about, so 5.1, the Lord Chancellor may make rules for regulating the exercise of the rights of appeal, and C, and so B for prescribing practice and procedure, C for other matters preliminary or incidental or arising out of such appeals, including matters of proof, and then rules under this section may in particular do anything which may be done by tribunal rules, and there's examples of that, and then into section 4, conferring on the Commission such ancillary powers as the Lord Chancellor thinks necessary for the purpose of the exercise of its function. There's nothing or nothing sufficient in those to say that included with those matters, ancillary matters, procedural matters, matters that go to the regulation of the exercise of a right of appeal, that costs are included in that.
Can I just be clear what that submission amounts to? Are you saying the Lord Chancellor, even if he had chosen to make rules establishing a costs regime, would have been acting ultra vires?
No, I'm saying that what you can't do is cut it back, having given, in this particular context, is having given such a broad power in 2D4 in particular, you can't then cut it back by saying there is no power at all until we say there is.
All right, okay. And can I, so you accept that in principle the Lord Chancellor is given vires to create a costs regime?
Yes.
Does he therefore have vires to create a costs regime which is potentially in favour of either side? Which wins?
Within the remit of 2D4,
what does that mean? That suggests that he doesn't.
Query whether he could now give a costs power in favour of the Secretary of State.
Quite. Presumably that's what you would be contending for.
Well, I would say he couldn't do that.
Sorry?
I would say he couldn't create it in favour of the
Could
Secretary of
not.
State. Not under 2D4. He can't really under 2D4.
No, but can he under 5?
Yeah.
He couldn't do something under 5 that didn't sit with 2D4.
Yeah. This is all, and that's not that's not in some of the skeleton arguments use the phrase mirror the costs regime in the administrative court. In fact, this would not be mirroring the costs regime in the administrative court, but would be effecting a quite radical change, with apparently no one having thought about it.
It's a much more radical change to remove costs completely. That's the answer. The intention here, with that language and that intention, is to mirror it to the extent. This is back to the point that you can do it all, except by what is a necessary implication. It is a necessary implication of 2D4 that you can't do it against the Secretary of State. It is not a necessary implication that you can't do it in favour of the claimant.
Thank you.
It's not a necessary implication
not a necessary implication of all of this, that because you've done it in that way, even the applicant can't have a costs order. Because the language is so broad.
Okay. Well, we may be going round in circles a bit. Yeah.
Can I just show you Morn briefly, because I referred to it?
Yes.
It's not precisely on point because it's about schedules rather than delegated legislation, but can I just show you, it's at page 414 of the authorities bundle. And this is about the burden of proof in inquests in relation to suicide and unlawful killing. But I just wanted to show you paragraph 44, one of the things that it does there, which is at page 432. And I don't need to trouble you with what the particular context here was, but they are talking about, at 44, that it would moreover be contrary to drafting conventions for a schedule for the rules to be used to make what would clearly be a change of some consequence in the law, and then quotes Lord Thring, halfway down that quote, all that can be said is that nothing should be placed in the schedule to which the attention of Parliament should be particularly directed, for example, the constitution of an electoral or financial body of persons, etc. So point here is be careful when you're looking at schedules, or we say also delegated legislation, etc. These are secondary tools of construction. Your starting point is, and they're not always reliable. The other point I wanted to just make before leaving this section and moving, because I do want to spend a little bit of time on Article 14, is just to note McCaffrey, and my Lord, I know that, of course, my Lord Justice Singh gave the judgment of the IPT in that case. And can I just emphasise there, can I just go to McCaffrey briefly? I'm going to start with, I need to find it. Sorry, it's page 699.
That's the beginning. Where do you want?
Sorry?
That's the beginning of it. Where
That's the beginning. So I want to go to page 704.
Yeah.
And it was the different there. The IPT there decided that there was no cost power there, and it might be desirable to have one, but it should all be left to the Lord Chancellor, which is the point that's being taken against me at the moment. But can I just point out that here we have section 2D4 in its broad language of any relief or any order, much broader, I say, than section 67 of REPA, which is set out at paragraph 28 at the bottom of 704.
Yeah, you're right to that extent, but one of your submissions this morning has been based upon the principles applicable on an application for judicial review. Now, that language is to be found in RIPA, section 67. If you go to the top of page 705,
yep.
Subsection 2.
Yes, I understand. But the context here, can I just make 2 points about that? One is that section 67 is a very different provision to section 2D4, because it shows that when Parliament was enacting this, it was thinking about lots of very specific outcomes. And as, my Lord, you say, at paragraph 70 of this judgment.
What page is that?
That is at the remedies that it has in mind are all substantive final remedies.
Yeah, I just want to find the page in the.
Sorry, it is page 714.
Thank you. Yeah, paragraph 70. Yeah.
So you'll see in the final sentence they are all exact. So in that case, specific consideration had been given to what they wanted to be able to do, and the only things that they were.
No, I appreciate that. Yeah. You're quite right to draw attention to the fact that there's no analogue to section 2D, subsection 4.
Yeah.
All I was putting to you is that it might be said there is some analogue to subsection 3 because there is reference to principles, but we did not construe principles in the way that you want this court to construe.
I understand.
I just want to give you the opportunity to say why we were wrong.
I'm not saying that you're wrong. I'm saying it's distinguishable.
I see.
Because the context here is so different.
Right.
Because they are bringing these. This is creating a new and inquisitorial jurisdiction. Is what largely inquisitorial jurisdiction in the IPT. It is not taking cases that already exist in the administrative court as judicial reviews and transferring them in. Yeah. And in that particular context, principles is elastic enough to get me home.
I see.
I'm going to turn. There are some other points in here, but I may put them up and reply. But I do need to spend a little bit of time on Article 14 before we break for the short adjournment.
Just before, it may not matter to the ultimate scheme of things, but because you've just made the submission that you have, and I want you to have the opportunity to deal with this. It may be said that it's not strictly accurate to say that that there was no transfer of proceedings into the IPT, because there's a provision in RIPA which provides that the IPT has exclusive jurisdiction over all Human Rights Act claims if they're brought against any of the intelligence services. Now, that could in principle otherwise, and previously could in principle have been brought in the High Court. And that was the subject of a decision by the Supreme Court in 2009 called A, and Director of Services of MI5, where the Supreme Court held that the partial ouster clause is effective. In other words, the Human Rights Act claims have been transferred exclusively into the IPT. So the net effect of it might be said is that whereas otherwise those claims under the Human Rights Act could be brought in the High Court, where there would be the full cost regime, in that limited class of case, they have to be brought in the IPT, which is a cost-free regime. Now, I just wanted you to be able to deal with that submission. As I say, it may not be crucial at the end of the day in this appeal, but it's not quite as straightforward as I think you were submitting.
It is, however, can I have the opportunity to think about that? I'll come back on that. I'll do that before, either after lunch, just before I hand over to my learned friend, or I will deal with it in a moment. Can I now deal with Article 14? This is because, I mean, I say I don't need this, but I say I don't need this. But Article 14 is, of course, at least in principle, capable of being a more muscular construction tool. And to the extent that I need it, and I need to have a costs order in order to construe Section 2D4 or to construe Section 2D3 or to limit the effect of Rule 11A, I say that I have it. Because the circumstance, as I introduced it and summarised it to Master of the Rolls earlier this morning, you do have this dramatic effect. You do have this comparator group of people who were, and indeed these individuals, who were previously in the administrative court with the full advantage of access to a costs regime that enabled them to access the regime, and who are then transferred in and treated significantly differently, including the point that with regard to FGF in particular, now doesn't have access to the funding regime and the facility for funding his action which he previously enjoyed. Now, excuse me, what is the justification for that difference in treatment? And as we are going through all of the explanations and we are looking through Hansard and the rest of it, there isn't any explanation at all for the difference in treatment. Now, my learned friend goes through, and we'll come to these, goes through some points, as she did below, in skeleton argument, etc., saying this is what the reasons may be, but there is not any decision-making, either in Parliament or anything else, or in a witness statement about decision-makers, or anything of that kind, that says what the decision-making actually was, that says that there was a positive decision to treat this group differently. And we decided to do it for the following reason. Now, there simply isn't anything that explains this difference in treatment. So if I say, in those circumstances, whatever argument we may have about the margin of appreciation or levels of deference or anything like that, whatever those may be, there isn't actually anything to defer to. And none of it makes any difference. And none of it is capable of justifying the difference in treatment.
I'm so sorry. Before you get to the need for justification under Article 14, you first have to get over all the other hurdles. SC, many decisions of the Supreme Court have set out what those hurdles are. And in particular, I think the point that's taken against you is that there has been no differential treatment on ground of a relevant, quote, status, unquote.
Because, well, I resist all of that.
Yeah.
The court, but can I take them in order? The court is the reason why I start with justification, and I'll come back to it and reverse the order in a moment. But the reason why I mention justification first is because, as my lord will know, that is where these cases tend to be fought. The Strasbourg courts and the courts here tend not to resolve these cases on the basis of questions like ambit or the nature of status. They don't tend to be troubled by those things. There are various routes into it. The question is there a sufficiently relevant comparator that calls for an explanation? Has the explanation been given? That's how these cases tend to get resolved. So I'm making the primary submission that things like ambit and whether or not I've got an other status for these purposes should not shut me out. This is a comparison exercise that is so obvious.
I don't understand that, I'm afraid. I mean, all legislation draws distinctions between persons all the time. That's what legislatures do. But what you've got to do is show that there's an incompatibility with Article 14, and there's a structured, analytical approach to that.
And I will do that, but I'm saying that if I can get, the only obstacles to me succeeding on this are A, ambit, I'm not within the ambit at all, and I say that's not a sufficient basis, or because there isn't any justification for treating them differently, really, when one drills into it, there isn't any decision making that says this is why we should be treating these cases differently.
Well, forgive me for interrupting. The comparator you're using is how the client would have been treated before the change.
Yes.
That seems to me a very odd use of Article 14.
My lord's going this isn't the need for other status requires. Shall I go through this in order? Shall I do the structured submissions and go through ambit as well, or you prefer me to address you on other status now?
Well, what's the answer to my lord's question?
The answer to my lord's question is this: the when can I just go to SC briefly on this?
I mean, there must be an answer in sort of ordinary language before we go to a case. My lord says, Article 14 says, the enjoyment of the rights and freedoms set forth in the Convention shall be secured without discrimination on any ground, such as other status.
Yes.
Right? And he says, you therefore need to compare yourself with some other group.
Yes.
In respect of whom you have been discriminated against.
Yes.
And the other group is not another group of people who are being treated differently from you in your situation. It is how you would have been treated before Parliament legislated. And that's not an orthodox approach. I hope, my lord.
That is exactly right.
So what's the answer to that? Is it why does it get you to first base? That's what we're asking.
Because I was previously in the group. You are now treating me differently. But I can also treat you differently by reference. These could be different people. Cohort 1, people who are seeking to bring challenges of this kind in the administrative court, who don't have national security concerns about them or some other reason for using close material. Cohort 2, people who do. Those are characteristics that the Secretary of State has applied to me. They exist independently of the reason for the discrimination, because the reason for the discrimination, the discriminatory treatment is to deprive one cohort but not the other of the cost rules and the cost provisions. That is a comparison between two identifiable groups of people, one with national security concerns, one without. That's the way I put it.
You're assuming entitlement to inter partes costs is a privilege, if you like.
Yeah.
It's a privilege which is, you say, being taken away.
Yes.
But doesn't that mean you're almost saying that every legislative change in anybody's entitlement to anything can be said to be breach of Article 14, and you go straight to justified, does this court or the Strasbourg court think that the change is justified? That's not what Article 14.
No, but when it's defining other status, I accept there has to be something here, and perhaps it is helpful to go to SC on this. Can I just show you A492?
Yeah. Paragraph.
71.
Yeah.
When they're talking, I mean, it also begins at paragraph 69, and it's referring to the cases with which I suspect the court is familiar, like Stott and Cliff. And Clift is a case about, you'll remember, different types of sentencing. I think it's between determinate and indeterminate sentencing. So it can be something that the state does to you. So the characteristic for the purposes of other status can result from something that the state does to you by making you a different kind of prisoner, like a determinate sentence or an indeterminate sentence prisoner.
So he explains that the cases in which the status requirement has not been found to be satisfied are few and far between.
Yes.
Well, that may be the case, but why is this not such a case?
Because, I mean, he's saying in paragraph 71, I would add that the issue of status is one which rarely troubles the European Court. So I am saying I don't need to do much to get over this hurdle. And there is something here, there is a characteristic here. The state has decided to classify, has decided that there is a cohort about whom it has national security concerns. There is a cohort about it doesn't have national security concerns relevant to its denial of the application for citizenship in FGF's case. It says things about those cohorts. That is a characteristic which these applicants now have. It then treats them differently, saying one can have costs and one can't have no costs. What is the reason for treating them differently? Now, you could say, you could say, because they are different, we're going to have a closed material procedure for one and not the other. That's fine, we understand the reason for that. But what is the difference with making the costs provision different? That's the point.
In an ordinary High Court judicial review case, everybody's potentially liable for costs. So there is a difference in treatment in SIAC, but it's not all one way.
But that goes to justification, not other status. Is my submission.
Right.
I have enough of a difference. I have an identifiable characteristic which the Secretary of State has put on me, those I represent, which means that I am in an identifiable cohort separate from the act of discrimination, and you are discriminating against me. Now, some of that discrimination is justified, having a closed material procedure. But the costs, what is the justification for it? I do say you can justify the difference in treatment by saying there won't be, and I've already said, by having a costs order, by having not allowing a costs order against me, because I have to commence the proceedings the only way I can get into the process. It's never unreasonable for me to. That is justifiable. But what is the justifiable difference for having no facility for costs for this cohort of individuals? And the difficulty that the Secretary of State has is there's never been any thought to this. I do invite the court to say, it just appears nobody's thought this through. And lots of people have assumed there was a costs order facility for at least the 13 years between inception and these proceedings. But see, ignore.
As it happens, as you've emphasised, this is a context in which there was a transfer of existing litigants into a new regime. But I just want to test how broad your submission about Article 14 is.
Yeah.
Is the effect of your Article 14 submission that in principle somebody could come and complain that, for example, they have to bring proceedings in a tribunal where either there is no costs regime at all, or there's a limited costs regime because you have to show the other side acted unreasonably, for example.
Yes, in principle, yes.
It does. Okay. So for all these decades, we've had, for example, the cost regime that we have in a number of tribunals. The Employment Tribunal is one example, but there are many such tribunals where the CPR cost regime does not apply.
Yep.
But your submission is this, is it? That in principle, the state is not entitled to have those different cost regimes, or at least it would have to show positive justification.
In principle, you can run all of those arguments, but absent the very particular circumstances that we have here, those arguments are likely to lose. Probably have. I mean, they failed in C7 in part because there was a pleading problem and they weren't in time. But if you're saying, it is a much harder argument for me to say, I'm running this in the tribunal versus running this in the administrative court. The administrative court, I have a cost regime. The tribunal is a different cost regime. It has a different cost regime. Then it is that's a hard argument, and my lord will know that tribunals generally are supposed to be relatively swift, informal, cheaper processes than court processes, and that's more true of some tribunals than other tribunals, etc. But what we have here is we have a regime where you've got, these are basically judicial reviews, same applicants. The only difference is that they have a national security concern about them. That's the other status that they have been assigned, and they are now running these in a jurisdiction where the absence of a cost rule may prevent them from entering it altogether, and that is the act of discrimination that needs to be justified. These are people who can't get access. It's not even the comparison with the tribunal, it's worse than that for them, as I said earlier on. These are people who are, not only do they not have access to the cost orders facilities in the administrative court, they don't even have access to the cost facilities available to them in the upper tribunal when you've got the unreasonable cost power. What is the explanation for that? Why are you treating this cohort so differently? So yes, in principle, the answer is those other cases could be run, but the merits of those arguments would be much weaker. I don't concede them, but they would be much weaker than the argument here is, where it is crying out for an explanation, and the only thing that we seem to have is nobody's thought about it. None of this seems to have been thought through, which is, did you really intend to do this? And it's back to the absurdity. And if you have a scenario where this is absurd and nobody can think of what the rationale for treating them so differently is, given all the consequences that that has, then I'm into Article 14 territory. And that's where I'm at. And I have to get it into Article 14, I have to be within the ambit. I mean, you've got it, part of this in my skeleton argument, but can I just touch on some of this? Stop me if you think I don't need to do this. The court below, of course, proceeded on the basis and the assumption that I was within the ambit. I'm focusing this on Article 1 of the first protocol, but I'm maintaining, now that's because I'm now representing H7 and H15, and they are, that's the only article that is available to them, but I've maintained the Article 8 also applies in relation to FGF because it was a refusal of identity. Can I just show you JCWI briefly, which is at 358. And I'm going to take this relatively quickly, but I do want to just dispose of the argument that I'm not within ambit. Can you look at paragraph 83, please? I think it's 388. Actually, start on page 81, paragraph 81. There's now well established and uncontroversial Article 14's freestanding provision. Then you've got 83. difficult to disagree with Baroness Hale that the English courts have made rather heavy weather of the ambit point. End of that paragraph, the ECHR has taken a relaxed and loose approach to the concept. Paragraph 87, there is an explanation of positive modality.
So which article is invoked here?
I say Article 1 on the first protocol.
A1P.
A1P. Because these are arrangements which we would otherwise enjoy. And I'll come back to why that works as a property right in a moment.
Arrangements that they would otherwise enjoy.
Yes, and which I have previously enjoyed, is access to a cost regime. And for FGF, on his conditional fee...
Do you have more in JCWA?
Yes. So 87, I just want to talk about the positive modality point there.
What does positive modality mean?
It means where the state makes available a process. So this is where it wouldn't, the convention wouldn't require you to set up a scheme, but when you set up a scheme, you mustn't do so on a discriminatory basis.
Yeah, a very good example of that is the state does not necessarily have an obligation to create an appeal system at all.
Yeah.
But if you do create an appeal system, you can't discriminate.
Yes. And that's what we say is essentially happening here. And if you look, the case I'm going to go to after this, I'll show you, is the special educational needs case of AA, which I'll show you in a moment. But you've got, this is a long and good description of how it works in paragraph 87, and then, and there is an uncertainty about how one decides whether something is a positive modality case or something else. And in this case, I am also talking about something being taken away as well as a failure to create, because we were previously in a cost regime, I've now been transferred and I've lost it. So it's stronger than the average positive modality case, but I'm happy for it to be analysed as a positive modality case. Then Lord Justice Hickinbottom at paragraphs 97 and 98, talking about the difficulties, touching on there of the definition. And then he says at paragraph 99, the ambit isn't restricted in that way. And then at 100, to be within the ambit, it's being linked to the exercise of a right guaranteed. It has been argued that even the most tenuous links with another provision will suffice for Article 14, but that may go too far. That's a reference to Nicholas Bratzer. But at the end, just at the end of paragraph 100, just before 101, the conclusion that emphasised that ambit must be widely construed, an uncontroversial proposition. But more particularly, it uses positive modality cases as a mere non-existent illustration of that way.
What's the case that says that arrangements, loosely called, are the same as peaceful enjoyment of possessions?
Well, can I park that for a moment? I'm going to get to that just in one moment. But just on while I stay on positive modality, can I just show you AA? That's another example of where it's done. Now that case fails, but they succeeded in relation to getting it within ambit, and that's at 563. This is a decision of Mr. Justice Singh, and this is the context here is generally if you have discrimination in relation to children, for example, having acts of discrimination have, like anybody does, have various rights of remedy, and those rights of remedy include, you can bring a race discrimination case in the county court, for example. But the problem here was, the action here was, the first tier tribunal is created to allow for those discrimination claims where it is in relation to disability. So if you're bringing in a case saying I've been wrongly excluded by the school because they haven't reasonably adjusted for my disability, then it goes into the first tier tribunal. But the first tier tribunal doesn't have facility for damages. you can't get a damages award out of the first tier tribunal. And that's an exclusive jurisdiction. So what the argument was is, the positive modality here is that you have created a scheme for the recovery of various remedies, including damages in relation to acts of discrimination. I can get that in relation to all other areas of discrimination by going off to the county court. Why am I being shut out in relation to essentially school cases, disability discrimination cases against schools, that go into the first tier tribunal? And the claim failed on justification because it was said that that was being justified. But the reason why I show it to you is because they were running the claim that, if you look at paragraph 48, we'll go to page 44 and 45, so page 571, please. Again, referring to the generosity of this, it's not hard to bring yourself within ambit. It is well established that a claimant does not need to establish a violation or an interference with a substantive article to be within ambit, merely that the discrimination is linked to or has a more than merely tenuous connection to a core value of the relevant substantive ECHR right, reference to Matheson. Then you see the way the claim is put. Then it says paragraph 48, it is said, I have a settled statutory right to bring a claim for damages which is good enough for a possession. That is dismissed as a route to ambit in that case. I say that we're slightly different to that because we did have at least an expectation of recovery on the previous arrangements. But in any event, you then look at paragraph 52. Second and alternatively, even if a claim under the Equality Act against the responsible body of a school for damages, save for in disability cases, is not a possession, then the claim is within the ambit of A1P1 as a positive modality case. So that's put in the alternative way. Then at 54 it records the defendant's response, which is accepted in relation to the first way the case was put. But then at paragraph 57, it's the claimants have succeeded on ambit in relation to the positive modality route. And I say that we are in similar territory here, because you have created a scheme that would otherwise apply that allows me to recover costs. But then you have, through your act, taken it away from me, if the defendant's the respondent's construction is correct, in relation to this cohort. Now that's about damages, and I'm about costs. And the reason why I say that's a distinction without a difference for these purposes is by reference to a number of cases that run it together. And this is the answer to my little question about this.
That's 57 is the answer to my question, you say.
Sorry?
57 of Mr. Justice Singh is the answer to my question.
Yes, thank you. But, I mean, can I just, they're in my skeleton, but you have cases like Tarhan, which I'll just show you in the Strasbourg decision at page 764.
But just pausing there, supposing Mr. Justice Saini's decision here is right, the class that are entitled to recover damages if they win are clearly in a more favourable treatment than the class who are not. But coming back to this, the difference between being in a costs recovery regime and a no costs regime is not as obvious.
Because I can't get costs against because I can't get costs against me.
Just so.
That I accept that, and that may go to justification, but it doesn't go to ambit. I've now lost some. So look, look at it most dramatically in the case of FGF. Having been transferred in, So say he's on the DCFA all the way through. Or say he's in a combination of the H7 and H15 scenario and the having a conditional fee. He's running his case on the basis of these economics. You take him into SIAC. The consequence of his CFA is he now, even if he wins, gets the decision set aside, he will now be liable for his solicitor's costs, because that's the way a conditional fee works. In the definition that you've got a positive outcome, you now pay your solicitor's costs. He has now been deprived of money, and it doesn't matter whether it's damages or costs, as a result of the actions of Parliament in moving him to SIAC.
So
he has a liability now that he didn't have before.
And how similar to the two different types of litigant have to be?
This is, well, they are very similar. These two cohorts are very similar.
No, I understand that, but just testing the proposition, Article 14 to be engaged.
Well, what I say about that is, and there are points to be made about deference and so on. And I kind of just, on that, I accept that we're not in one of the areas where it's a suspect ground. We're not dealing with, it hasn't been created on racial grounds. It's another status ground. I see all of that. But it is an area where you're looking at different costs treatments, and it's an area where the court has expertise and knowledge. This is not an area where you're dealing with macroeconomic social welfare type situations where there is material that you don't have that's not before the court. So it is an area where you can be confident and you don't need to defer very much. But assuming I'm right on this, you have taken somebody, or you've taken a cohort that previously had a route to challenging these things.
Well, why should that matter? Why should it matter that it's a change? And suppose all these systems had been set up on day one.
Yeah.
Science was first created. You would still say that
I would.
That it's discriminatory.
I would. It's just the change makes it, from an ambit point of view, it begins to look. It's definitely a positive modality case, but it also looked a little bit like a deprivation case because I had this before. The injustice is more stark when you see, for example, H7 and H15 proceeding in this way and winning. They were getting the decisions withdrawn. The secretary, and they were being able to do that because they were represented. And on the evidence that you've got and accept, that part of the reason why they're able to get represented is because inter partes costs were available and conditional fees were available, etc., etc. And then that suddenly stops. I would argue it even if it was a completely new regime. I'd still be doing the comparison. I'd just say the injustice is that more stark when it's the same individual. You've just taken something away from me, and something fundamental, because it now may be stopping me, certainly real risk to use a unison test, of being able to carry on successfully challenging this process. And you've done it without explanation. There's done it without any thought. There's nothing in Hansard or anything else. There's no decision making. There's no, look at all the consequences of this. Look at the fact that I may not be able to sue at all now. What's the explanation? And there isn't one. And it calls for an explanation. And if it can't, then the court needs to use Section 3 to construe what would otherwise be the language of, I say I get home on domestic anyway, but you can be more muscular, see Guidon Mendoza, etc., under your Section 3 duties.
Yes, sorry, but can I come back to the last question? I'm interested in where the discrimination on the grounds of other status is. The other status is that you're a type B litigant rather than a type A litigant. How similar do type A and type B litigants have to be to engage Article 14? Or could, for example, a claimant in an employment tribunal say it's outrageous that I can't recover costs? If I were claiming damages for personal injuries, say, I would be able to recover costs. Therefore, you, the state, are discriminating against me on the grounds of my status as a litigant bringing an employment claim rather than a common law claim.
They might, but this is similar answer to the one I hope that I gave to Lord Justice Singh, which is that they might be able to run that case, but the differences between an employment tribunal litigant and a SIAC litigant are much wider, different kinds of rights, and different kinds of relationships than this one. I don't need them. I mean, the question, the legal question, which you get from SC and elsewhere, is are they relevantly analogous? And in this case, where they're exactly the same people until they get transferred, with exactly the same applications and exactly the same characteristics, until the Secretary of State decides to classify them differently, saying you're a national security concern and you're not, then they are so close that on any reading of relevantly analogous, to use the phrase that was used in SC and elsewhere, I'm there.
Thank you.
And can I just show you briefly Tarhan? I mean, the essential point that you get from Tarhan, and I'll just, what happens here is it was a compulsory purchase process, and he succeeded, and he got damages for that, but he lost money because he was forced to pay cost, and you get that from page 773 of the authorities bundle. Just so you have this, paragraph 72 at the bottom there. In the circumstances of the case, the question which arises is whether and to what extent the fact of ordering the applicant to defray some of the opposing parties' legal fees amounts to an interference with his peaceful enjoyment of his possessions. Indeed, the sum of money which the applicant had to pay in respect of fees partly absorbed his appropriation award. So what that was about is it's making the point that I made earlier, which is it doesn't matter whether it's damages or costs, it's a liability either way. You have lost money as a result of these cost provisions. And I just, if you look at paragraph 78 is the other sideline provision. I'm not going to take you through it now given the time, but and that is, so that was something that you would, by not having the cost provisions there, deprived him of money, and that was enough to get him within Article 1 first protocol. That's the same thing that applies to FGF in particular, because he loses money because of the way the conditional fee works. And that is a question about, that was a question about Article 1 being satisfied. There was therefore a violation of Article 1, Protocol 1. I don't need there to be a violation of this, I just need it to be within the ambit. Much lower threshold for me. I then want to just show you briefly, just to make sure you've got it for your note, is page 287 of the authorities bundle, which is the case of flood. That is where claims have been brought against Times newspapers and others, and there was a challenge to the level of success fee, other aspects of the conditional fee agreements which failed. And I just, that's about the importance of these things to access to justice. Can I show you page 387. Actually, can I just show you paragraph 3 first of all? Go back to that. So this is about just making the point, this is the Supreme Court describing in paragraph 3 at the bottom of page 293, just where that highlighting is. Just let you note that. Making the point that I've made, which is that civil legal aid, the civil justice system now depends upon things like conditional fees. And removing it in that context, you go to page
Paragraph 46.
yeah. plain injustice on Mr. Miller to deprive him of the ability to recover the success fee would, in my view, infringe his rights under Article 1, Protocol 1. That again is about violation. It's not about ambit. I only need ambit. So I say that when you're doing these things, something as foundational as this, which is a possession I have, a cost arrangement that I enjoy in order to secure access to justice, then that is sufficient to get me within ambit. You may want to note too that there was particular concern about the access to justice implications of that, paragraph 49, and the and then paragraph 55, the impact on lawyers too, if they can't enjoy that. You've seen Mr. Carey's statement to that effect. So you can, as I say, you can justify treating the two cohorts differently. One has a closed material proceeding, one doesn't. But when you're dealing with something as foundational as the cost regime, which can mean, and there's certainly a real risk, and would for FGF, mean the difference of getting into the system and not getting into the system, then that is something that needs to be explained. They are closely comparable. They are the same individual until they get transferred in, as I say. And then, what does the Secretary of State say about it? And what you have there is my learned friend's skeleton argument at page 61 of the core model. And what she says here, and I say that none of those pass muster in terms of justifying such an impact. The fact that SIAC is highly specialist doesn't matter, because you've got, there are cost orders elsewhere in tribunals. Why is there none?
Can I just ask you what you, let's assume you get to justification, and let's assume 2D4 does give you a right to cost, one-way costs, in a particular situation. Do you still say that Parliament's decision to leave the rest of costs to Section 5 is A, discrimination, and B, unjustified?
Yes, because the that would, in the particular circumstances of these applicants, that doesn't help them. They don't have a cost order. Why?
So you say then you take your category of persons down to people who bring claims in SIAC because they have a national security concern and have their claim withdrawn, which in the administrative court would give them a right to costs.
Yes.
But I suppose your point really is a slightly broader one, which is that it removes the access to justice. You can't challenge a decision in SIAC because you can't get a lawyer to act for you because there is no general provision for costs, and there is the carve-out for the government to simply withdraw and thereby scotch the lawyers' recovery of fees.
Yes, all of them. and I do want to emphasise, and I know the court will already have it in mind, see all the other points, but it is really important that, the person standing on this side of the court, this really matters to those who represent.
No, I understand. Well, it's 1 o'clock.
Yes.
Mr. Armstrong.
Yes.
You had better restrict your after-lunch submissions to 5 minutes.
Yes, I'll deal with the point.
And deal with my lord. 2 o'clock. Thank you.
Court, right,